Hello, and welcome to a joint meeting of the Regulation and Discipline Subcommittees of the California Paraprofessional Program Working Group. I can take roll now. Bashan.
Here.
Falmouth.
Here.
Hartston.
Here.
Kirkmeyer.
Here.
Sarouche.
Here.
Spiro.
Here.
Great, everybody is here. Can see if there is any member of the public. At the moment, we have no attendees. I think this was maybe a little bit too arcane for the public. So maybe we can get started. And Leah, do you want me to share the PowerPoint that was created?
Yeah,
That
sure.
can help
Just
frame the discussion.
Kind of summarizing the information I sent out via email and then Amos's additions. And then I don't know, Amos, if you want to just move to your proposed resolutions that were open.
Okay.
Yeah, I can at least give an overview of them. Happy to.
Okay. So these were the concerns that were identified, the potential risks for of UPL with the paraprofessional program. And this is a very high-level overview of some measures that were discussed to help to reduce the risks of the unauthorized practice of law. And then the following slides go into a little bit more detail than this. So in terms of increased funding, we talked about increased funding for law enforcement agencies, for the State Bar's Office of Chief Trial Counsel, and also providing funding for victims of UPL. We discussed some statutory changes that could be implemented, allowing felony charging, as we had heard that UPL is they can only prosecute as a misdemeanor. So we talk about allowing for charging of felonies in certain circumstances, extending the statute of limitations for these cases, and also expanding the State Bar's prosecution authority. At this point, the State Bar can investigate and provide information to law enforcement agencies, but the State Bar doesn't really have any jurisdiction over people who are not licensed to practice law. We talked about also just ensuring that there are bright line rules and that that consumers are aware of what is allowed by paraprofessionals. And this sort of goes into that a little bit more in a little bit more detail. And then in terms of services for victims, in addition to a compensation fund, we talked about ensuring that victims can obtain legitimate legal services if they to address the harms that they have experienced. And then we also have added a couple of slides that provide the detailed recommendations that Amos sent in the email that Leah forwarded. And so maybe Amos, if you want to talk about these a little bit, or else we can just move to your resolution. But I don't know if you want to take the opportunity now to go into a little bit more detail on these.
Sure. So I didn't see the prior slides. I think a lot of what's on this slide is already captured in what you captured in the prior slide. So I think it's great. I just want to again thank you for setting up this follow-up meeting of the two committees, because I think we independently came to the same conclusions that addressing unlicensed practice of law really needs to be part of standing up this program. And I think the real issue is, what are the next steps? because I think Leah sent around a fund proposal or language, but I'm not sure that's something that the working group is going to be proposing or specifically, and it didn't include amounts and those kind of details. So I think for me, it was what steps should we be taking to make sure we highlight this risk and the need for regulation, and it sounds like statutory changes and funding related to this. So I put together just some draft resolutions based on, I don't think it's these bullet points. I don't know, I haven't seen these slides, but it really, I think, captures 80% of what the original slides were. I think there were a couple on there that we may want to add about the bright line rules. It must be clear what paraprofessionals can and can't do in public education. I don't think I captured those, but do you mind just putting up the draft resolution?
Sure.
It's just as a starting point for discussion, just trying to capture that both of our committees independently, heard testimony, read or heard public comments very loudly from law enforcement, legal services, consumer advocates, that this really can't be missed. This is really an essential part. So maybe give people a chance to review this, and just as a starting point for discussion.
Yeah, just there.
Just as a staff comment, I would ask that the group consider the word expected in the first resolved. I think some people argue that it's going to increase. I'm not so sure I necessarily see it. And I don't know that it changes really substantively the resolution to just say has identified increases as one of the primary risks.
I think that's fine.
Yeah, I strongly support deleting that word. And I don't, to me, primary doesn't belong there either.
Well, that was from the regulation subcommittee, at least. It was one of the top 3.
Oh. So they did identify it. I mean, what does that mean? How did they identify it? I don't remember. I went to their
That's
meeting.
one of the things we're sort of trying to document that here. So if you have comments, obviously we can include it, but this is, I sent around an email, I think, summarizing that background. I think generally, just to comment, generally, I think legal services in particular, I think this is one of their, and I'll use the word again, primary objections to the entire program, thinking that it should not be created, as an example. But I think law enforcement has also strongly objected to the entire program with this as their key objection and concern.
Can I say, I hope I'm not interrupting or out of turn or something, but to me, it's not our working group that's identified this or thinks it's primary. I think that what really this should say is that the working group has received comments from credible sources, I guess we could say, received comments that unauthorized practice presents a risk of creation of, you know what I'm saying? The comments that the program would present a risk of unauthorized practice of law and fraud by non-licensees. I'm not convinced that's true, but the police and legal aids and maybe others think it's true. They don't really know either. Nobody could possibly know, but I wouldn't go farther than saying that we've received comments from these sources.
Well,
I put our imprimatur on that, and we don't know, and we're guessing.
But I do think that there are members, certainly Amos and Fariba that did feel that this was a risk. I just wonder, I know I shouldn't say this because I just wordsmithed previously, but it could say as one of the risks of the creation, as an important risk, a significant risk.
Well, it's not so much that adjective. It's what we're saying. It's saying that other sources have expressed that there is this risk, not saying that we've identified it. I don't agree with it. Some members do.
At least on the regulation subcommittee, and they're all here so they can speak too. But we were specifically charged, I think, with identifying risks and proposing regulations for those risks. And we have identified other risks and we've proposed regulation. And this is one where we have identified it and we haven't proposed. So this is coming to the joint committee, because my understanding was you were at least investigating it parallel to us. But I'm not tied to this language. I just feel strongly we shouldn't water it down. So if we couch it that way, I think we might need to add some facts like law enforcement, legal services,
that's fine.
Consumer advocates strongly, have raised this multiple times. So if we're not saying we've identified it, which I think is accurate, at least for the regulation, I think we need to provide detail to show that this is a serious concern that needs to be addressed.
Well, I think I'm sorry, Amos, I appreciate what you're saying. I understand. However, my one point I'm making is that I'm saying that the working group has identified these risks. It suggests that we've done some kind of study and we've gotten data, and maybe other states have shown that there's these increases, but none of that has happened, not even from the police or the legal aids. So I think we've got to say that it's other groups, and we can name them if we want. They're credible groups. Other groups have expressed, I don't know if they've identified it either in the sense of doing research, but they've expressed that they think, or their belief or whatever it is, that there is this risk. I think it's got to be watered down. I think it's misleading in the way it is.
What do others think?
Yeah.
Kim has her hand up.
Sorry.
That's okay. I mean, I think the only thing maybe we could change it to is the working group, and again, not to wordsmith either, but the working group has heard that increases in the unauthorized practice is one of the primary risks of the creation of a new program. You could do that because that is something that's factual. But I actually had my hand raised because I would actually like to add to this list, and I want to make sure that in what we're doing with the citation and fine program, that we make sure that unlicensed activity is something that the bar should be able to issue a citation and fine for too. I think we talked about that in the discipline committee, and want to make sure, because that could be the first step that you go down, and then if they don't pay it, you can report them to franchise tax board. But I want to see if that's something that individuals would be okay adding that onto here too, to make sure that the laws or rules or regs or whatever it's going to be covers that as well.
I think that's a good idea, because I think it would be great to draft up that resolution here so we can make sure that it's incorporated into the final discipline structure.
And then
it seems like that would require a statutory change to give the bar authority to impose fines on people who are not licensed.
That's fine. A lot of our proposals require statutory change. I think that's fine.
Yeah.
And just along those lines, that's another way, just thinking of how some of our boards, like our contractor state license board has like a SWIFT program where they go out and take a lot of action against unlicensed individuals. And they actually work with local law enforcement. That is helpful because like for them, then you don't really have to have a sworn position on like the state bar. You could use like non-sworn and use like local law enforcement and the DA's office, which I know they have limited resources too, but because they can get grants and things that sometimes state agencies can't do. And they join forces with Franchise Tax Board and other entities to go out and, take action against unlicensed. So that way, Leah, for you and for State Bar, it's not solely put on the back of you all.
Okay, so for the first resolution, I see Julie, you have your hand up, but Kim's suggestion was the working group has heard that is the primary risk. Julie?
Yes, I agree with Ira and Kim that this, I don't like to use the word watered down, but I agree with Ira. We don't know that this is going to happen. We don't know that it's going to be a problem. And we have heard from many groups that they think it will be a problem. In fact, no matter what we talk about in this working group, somebody steps up and says, oh, that's going to be a problem. But I do think we should make this clear that we haven't done the study that Ira mentioned or that this implies. We haven't done anything like that. We've just heard from these groups and we're not avoiding or ignoring what they're saying. And we want to try to address it if we can. I agree with Kim that a mention of the citation and fine program, which the discipline committee has looked at and adopted, I think, should be made in this. And also that deputy district attorney who has testified before probably both of our committees, I think her name is Ryan, she emphasized the need for serious consumer education as to what paraprofessionals can do and cannot do. And I think that should be included as one of these bullet points.
Okay. I don't know if it goes in the structure of that resolved, those bullet points, because that's about new laws and increased resources. I think it's a different resolved, maybe.
It may be.
Clarification of scope.
Yeah. I didn't have a chance to look at this before, 2 seconds ago.
Yeah, no. So I think maybe it's a further resolved around the California Paraprofessional Working Group. I don't know if it recommends that the state bar ensure that adequate resources and attention are paid to like clarifying the scope of the program, the scope of the license for consumers. I feel free to tear that up, but I think it is a different resolved. To consumer education. The scope of the paraprofessional license.
But wasn't one of the concerns that is not that there's going to be UPL necessarily by paraprofessionals, but that other people will come in and pretend that they have the same authority as paraprofessionals and can provide the same kind of services. So I think it's beyond just the scope of the paraprofessional license.
I think that's correct, Linda. That's a big concern.
And I think what we're thinking though is, what I'm thinking anyway, is that by saying the scope, they'll know that, okay, this is what a person with a license is supposed to do. So this person is unlicensed, so they shouldn't be doing it. That was my thought.
And it goes in both directions too.
Right.
There's people who are completely unlicensed who shouldn't be doing what a paraprofessional can do. And then there are things that lawyers can do that paraprofessionals can't do. And so the consumer education program ought to go in both directions.
Do we need to add another resolved around the citation and fine program, for lack of a better word, applying to perpetrators of UPL?
That might
Could
fit
we
in the
just-
third bullet point.
Oh, yeah, that's true. Could go there.
And that bullet point, you might want to say additional statutory changes, funding and resources, since that's what you're talking about there. I had my hand up, but it may be hard to see. There's one other thing with the first resolution, because I'm recalling those conversations with the deputy district attorney. And this has actually been one of my issues. People have touched upon this, but I just kind of want to expand on it a bit. Since the beginning, this idea that there's going to be increased UPL by virtue of the creation of this program. I've always struggled with that position, just because it seems to imply that by creating this program, there are a significant number of individuals who otherwise would not have committed fraud, who will only do so by virtue of the fact that this program was created. And I remember pressing a little bit with the deputy district attorney, Ryan, I think was her name, what Julia said. And I think what I understood her to mean, and I think this is what some people have already said, is it's not so much an increase in UPL that is the concern, but it's by non-licensees, but it's UPL by non-licensees claiming to be paraprofessionals, or paraprofessionals exceeding the scope of their licensure, which somebody has already alluded to. But this resolution is sort of worded more broadly than that. That's one thing. And the other thing is, and this has already been touched upon by other people, it says it's identified as one of the primary risks. I think because we haven't done the type of studies to determine whether or not that's true, you might want to couch that a bit with primary potential risks.
I agree with all of that, by the way, Greg. I think that's a fair characterization of at least some people, how they've articulated the concern. And I don't think it's on a blank slate. I think law enforcement and legal services has had experience with other, existing or new creation of authority that has led to non-licensees, holding themselves out to have those credentials when they don't. So it's not like it's a guess. It's based on, years of experience and very strongly viewed. But I think that is probably a better articulation.
Right. It's almost as if you're creating potentially a new method for somebody to engage in UPL by creating the program. And that's what I remember the deputy district attorney saying, that every time we've seen one of these new professions created, we see an increase in UPL by people claiming to be within that profession.
Exactly.
Is your hand up, Amos?
It's probably changing the topic a bit, but really a question for Greg and Brady. So I think one of the other things that I heard loud and clear, and it made it into the slides, and it's really the first bullet point, changes to statutes and available remedies, particularly making UPL chargeable as a felony. Is this enough detail for staff to sort of add that to the statutes that we're recommending? Do we need to dig a little deeper to say what statutory changes we want? Because I think that probably should go on the list of statutes that the working group is recommending.
Well, I mean, at least initially, standing up the program, the statutes we're recommending are going to be, you know,
Right.
as far as statutory text, I think likely to be the statutes that are needed for the program. You know, I don't foresee us, unless a lot more work is done, writing, you know, and recommending new criminal penalties, or, you know, much going beyond this bullet as something that we recommend as a policy matter.
But I think that's what we're recommending. And so I'm glad I asked the question. What would it take for us to put in the resolutions for the working group to have the statutes that are being recommended to stand up the program include this? Because I think this, again, although it sounds like there's a little bit of concern about the testimony, that's probably not the right word, but about what we've heard as, this is sort of the public protection part, right? Of the mission of the working group. So it's true that there are other statutory changes that are important. I think we want to propose this one as equally important to other statutory changes we're recommending. Again, for discussion, that's my position. And I would like to get this proposed recommendation in the statutes. You know, the working group and staff are proposing to stand up the program.
You're muted, Leah.
Yeah,
Ryan has done a lot of this. I don't think it's that onerous of a task, but that being said, it's not currently contemplated as being included in the work that Brady and his team are doing. And I'm just a little reluctant to commit them right now, given what they do have on their plates. Happy to have Brady take a look at the more detailed information Ryan has provided. And, you know, if that's something we can incorporate, we will. Otherwise, I would say that the conceptual recommendation is there, and it could be something that the board directs staff to do after its September board meeting for inclusion in the package that ultimately goes to the legislature in March.
And Leah, this is Joanna, just for a second. I just want to concur on what you just said. I am not on board with giving them more work at this juncture.
Okay, I hear you loud and clear, so I will shut up about this now, but I will just say this is critically important to public protection. So I think we need to focus on that part of the working group's mission as well.
No, absolutely, Amos, no question about that. And I think, as Leah said, you know, we can highlight this and it'll be part of what we bring in September. And I would, you know, I will be surprised if there isn't a directive at that point for there to be additional work, but it's a matter of who and when and the timing of it and who's giving that direction.
Okay.
Looks like Julie has her hand up.
Yes, thank you. Just real quickly. I realize that the State Bar's Office of Chief Trial Counsel and the DA's offices work very closely together on these kinds of issues. But this particular one, whether to charge as a felon, whether they should have the authority to charge felony or misdemeanor is more uniquely within the province of the DA's offices and not the bar. Similarly, the funding for DA's offices is within the discretion of the DA's offices. I think the bar's position could be the bar supports the DA, any proposal by the DA for authority to charge a felony or for additional funding for UPL. Just to kind of reword this a little bit.
Maybe. I do think what Ryan would say is they're not, because of the way that the DA works, we'll have better luck getting this statutory amendment than they will. She hasn't said that to me, but I think that's like, if we're serious about it, we should probably try to push it.
I would agree with that assessment, Leah. I've spoken to Ryan about it, and I think that she's intimated exactly that.
Any other feedback on the proposed resolutions?
So I have a question about the additional funding. That would have to be statutory, right?
Yeah, if we wanted general funding, or in addition to the attorney licensing fee, those would both happen statutorily. And I do have to say, I think we had a real missed opportunity this legislative session because there was so much money in Sacramento, and it would have been a great time to try to get that initiative that I sent the attachment about to actually get it funded. But I think we could try next legislative cycle, this pilot program, with regional DA's office is doing DA's office is doing regional prosecutions. But that's all legislative general fund money.
And do we have a ballpark number in mind?
No, we never got that. We didn't get that far, and it would depend on like how many how many programs were established and how big they were. We could try to figure that out probably, but to do it with any reasonable scale, it would be, in the millions.
Right. And I guess my other question has to do with bullet point number 3, which is the additional statutory changes, funding and resources for the Office of Chief Trial Counsel to investigate and address UPL. And that would include coordinating legal services for victims. The way it works now, it's usually legal aid organizations that are absorbing a lot of these cases and trying to help the victims. Sometimes there's just like no redress because the harm is so bad. Would we be asking for additional funding for legal services? I mean, that's something that we really need to consider because these organizations are stretched so incredibly thin. And they are going to be even more when, the moratoriums are lifted with housing. So it's just something for us to really keep in mind as we're trying to stand up a program.
We could add legal, more funding and resources for the State Bar's Office of Chief Trial Counsel. And shouldn't we have DAs and legal services organizations all in there?
So DAs is the second bullet point.
Okay. We could add legal services. Because one of the things I have been thinking about, Sharon, it's something I talked to the head of Caresen about a long time ago when I first came to the bar, was whether legal services organizations could even do some of the front end intake an initial investigation work for the bar, because the reach into the community is so much greater, and these organizations are more trusted than the bar. You know, one of our issues is people don't want to report things to the bar. So this, you know, I think there are ways to really create a very intentional partnership in this area.
I think that's a really creative idea. It would definitely take funding, but I hear what you're saying about community trust.
Yeah. Did you want to talk, Amos?
Just a quick similar point on the last further resolved. I think it's down below. Is this one, so this was added, just added during our discussion. Is this one for the bar to fund? Or who's doing the consumer education? Is for the state bar to do this?
Yes.
So maybe we should say that, because everything else is really for legislature or is this, yeah, okay, that makes sense. Thank you.
Are we ready to take some votes on these, or do we need to, Linda? You're on mute.
If there's general agreement, I don't think it's necessary to take a vote. I mean, if there's anybody who has strong objections, then we can vote. But if there's general agreement, I think we can just put this forward, you know, in a memo to the working group from this joint subcommittee. Is there anybody who feels a need to take a vote, or
Julie's
anybody
hand.
I don't really need to feel the need to take a vote, but I'm just, of these bullet points that are here, aren't some of them directly addressed by regulations that have been formulated and proposed by the regulation committee? Like record keeping requirements for paraprofessionals?
I don't think there are any current record keeping requirements.
Oh.
Well, let me ask Brady or Greg, in the rules or the State Bar Act, aren't there record keeping, or that's just for criminal defense attorneys?
There's record keeping requirements for your client trust account under the standards and rule 1.15, but in general, in terms of record keeping client file, there are no rules about that, how long a client file should be retained. There's rules pertaining to turning over the client file at the termination of representation. But you were alluding to, I think there's a statute for criminal defense attorneys. They're required to retain their client file for the period of incarceration. And that's a new penal code provision, I think, that was passed a couple of years ago. But lawyers are not, there's no general requirement for record retention for attorneys beyond those provisions.
And to answer your question, I don't think any of the other ones have been addressed by the regulation subcommittee separate from this. I might be wrong if somebody wants to correct me. Leah, I did have a question about that fund proposal. Is there anything that you need this group to do to move that proposal forward?
No, I think it's a way of doing number 2, additional funding and resources for law enforcement. So it's to give you guys an idea of like a more concrete proposal that we had actually put forward. It didn't go anywhere because the fiscal climate was quite different. So I don't think so. Like I said, next year may be a really good year to do it if we continue to be in a positive revenue environment statewide. Brady?
I was just going to mention that just as a process point, if we adopt this sort of resolution that's sort of, new laws and increased resources are needed, potentially included creation of record keeping requirements, since that's as we just established, something that we haven't discussed in detail. I would see that as something that sort of goes on the to-do list for the paraprofessional board when it's created, maybe later this year, or earlier next year, in that list of more detailed state bar rules that it would need to propose, program rules. Is that how you would see sort of a general recommendation like this going?
I'm not sure.
So record keeping, I think, could either be court rule. I don't think it, I don't know if it's, maybe this is a question for Greg. I don't know that it's a rule of professional conduct. It might be able to be done by a court rule or statute. If it's court rule, then it might be something that we can take up, right? The regulations subcommittee. If it's statute, I think we're trying to follow the recommended statutory changes.
There will be, we already envision, and these aren't fleshed out, but some equivalent to that. There will be some program rules in the state bar rules, which will include, what sort of records and information you need to keep updated with the program. So this could conceivably the state bar could be given authority to create this kind of rule, in which case it could be a state bar rule.
Okay, so state bar rule or court rule, because I think that's where we're putting like MCLE requirements and things like that. So I think all of those options are open.
Okay.
So is there consensus about the way the resolution is written now?
I think people wanted to take out the word primary in the first one.
Okay. Well, we don't need to vote. We're all good. Linda, maybe you can send this out after the meeting. I think that's it.
Great.
Anything else? All right. Thank you.
Thank you.
Thank you.
Bye.